morning, Commissioners.
Are you well and relaxed?
A little bit nervous, but I think with time it will ease.
All right. Where did you obtain your degrees? Your BUris and LLB?
I obtained my BUris at the University of the North.
When was that?
That was in 1993.
Yes.
And I did my LLB, which I completed in 1995, the same university.
Did you then immediately go to practice?
The following year, 1996, I made an application to the Pretoria Bar for pupillage, and I did my pupillage in 1996.
Yes. And when did you begin practice?
Chief Justice, I did my pupillage in 1996 and 1997, and from there I immediately went into practice. In 1999, I joined the criminal law bar, where we specialized in criminal matters.
Yes.
But members were not restricted to take work in other fields of law. But our specialty was criminal law.
Is that the bar known as the Church Square? Is that the Church Square Society of Advocates? What? I forgot the name.
No, criminal law bar is
It's a different one.
It's a different entity.
Okay, then I'm confusing you with another candidate.
Yes.
I'm sorry. Yes.
No, I'm a member of the Church Square bar.
Oh, okay. Okay.
Yeah.
So it's a different one altogether.
It's a different one. I had a liberty of being in the same bar with the late Judge Judicial in a criminal law bar. And in 2001, I joined the Church Square bar.
Okay. Okay. So if you add up the total period of your practice as an advocate, how long have you been practicing as such?
Up to now, it's 21 years, Chief.
21 years.
Yes.
And for how long have you acted as a judge?
I started acting as a judge on the 10th of October 2016, and I did 7 terms, which
yes.
is 66 weeks.
6 weeks.
66 weeks.
66 weeks.
Yes, Chief Justice.
Was it difficult, very difficult, or easy to cope with?
I cannot say it was difficult or easy, but transition for me, it was not that difficult in a sense that when I started acting, I was given criminal work to do.
Okay.
And that's basically my field of specialty, and it was easy, and I am exposed to court attendance. I do appear in court on many occasions, yeah. So it was not a difficult thing for me to do.
A few colleagues struggle with reserved judgments. Was it your problem as well, or not?
With regard to criminal trials, I can't say I picked up reserved judgments, because normally after hearing evidence, I summarize. I summarize the evidence on a daily basis, and then immediately after arguments, I'll deliver my judgment.
Yes.
With civil matters, it's something different.
It is?
Something different.
Yes.
There are complex matters that you cannot deal with them immediately, and then you have to reserve judgment. But I make it a point that I deliver my judgment timelessly.
Well, what is the longest period you've kept the judgment reserved for?
I can't remember reserving a judgment for more than 3 months, CJ.
You've never reserved it for 8 months, 1 year?
No.
Yes. Very well. JP?
Thank you, Chief Justice. Advocate Mosopa, good morning.
Good morning, JP.
You've acted for a total of 66 weeks, and you confirm that the bulk of your acting time has been in the criminal trial courts.
That's correct, JP.
Right. But you have been put in other work areas. I mentioned the opposed motion court, where you spent 5 weeks there.
That's correct.
How did you find acting in that court?
Opposed motion court is a very challenging court, JP, to say. But you are given files timelessly 2 weeks before the hearing of the matter. And with counsel having prepared their heads of argument, that makes work easier for you. You read your files, you read the heads of argument, you do our own research. And as a result, I didn't find it so much difficult, but it's a challenging course to see.
Right. And as I note that you sat in about 5 full court appeals.
That's correct.
Did you write any of them, the judgments?
I wrote some judgment in those matters.
Okay. Thank you, Chief Justice. No further questions.
Thank you, JP. MEC Lesufi.
Thank you so much, Chief Justice. Can I just catch my breath? I'll come later if she saw that.
Commissioners? Yes, you may catch your breath. So you'll come later?
If you don't mind.
No,
Chief
it's
Ju-
fine.
I really have several questions, so I just want to order them.
No,
out.
it's okay.
Thank you
Yes,
so much.
Take your time. Commissioners, any of you? Commissioner Kane?
Good morning.
Good morning, Commissioner.
There's an overview of your application and some of your judgments before us prepared by the GCB. And the issue pertaining to the manner in which you dealt with an 11-year-old girl's case.
I'm sorry, Commissioner, I can't hear you properly.
Is that better?
Yeah, it's better, Commissioner.
Thank you. I'd like to raise with you the GCB's presentation
Yes.
and overview relating to a case in which you were dealing with a rape victim or alleged rape victim who was 11 years old. The matter came on appeal before you and you overturned the conviction and the sentence. Are you aware of the case I'm referring to?
I'm aware. I've seen the GCB comments on that matter.
Now, the cogent criticism, or most cogent criticism from the GCB appears to be that the evidence of the forensic nurse that examined the 11-year-old after the incident confirmed the kind of injuries one would expect to find for a girl that had been raped. How did you deal with that in your judgment?
Yes. Before I answer the question, I just want to give the overall picture what happened in that matter. That matter came before myself and another judge as an appeal matter from the lower court. I had the benefit of dealing with the most senior judge in this division, who's also well experienced in criminal work. We had an opportunity of reading to the record of the lower court proceedings. We discussed the matter, and in our view, we are of the opinion that the evidence doesn't confirm or support the conviction. We looked at the evidence of the forensic nurse. The forensic nurse confirmed that the child was sexually assaulted. But unfortunately, due to the delay in reporting the matter, there were no DNA conducted to prove who's the actual perpetrator. The child might have been sexually assaulted, but the question is, was the accused who's the one who actually assaulted the child? But we couldn't find that evidence on record. And that is why, and based on the fact that there were so many contradictions in the evidence of the child, and the fact that the report she made to the forensic nurse, who actually testified on behalf of it, differs completely with what was said by the child. And it was upon those reasons that we said that the conviction doesn't, the evidence doesn't support the conviction, and we set it aside. But I like to add, and I've dealt with that in my judgment. After the conviction of the accused requested a pre-sentence report. A social worker was assigned to interview both the victim and the accused. The victim, the child, said to the social worker that the accused didn't rape her, but the aunt is the one who said to her that she must tell the police that the accused raped her. The matter was brought to the attention of the prosecutor in the lower court, and the prosecutor assigned the investigative officers to obtain the statement from this child. The child confirmed what he said to the social worker that the accused never raped her. That is before the court in the lower court, and it was handed in as exhibits. That is the pre-sentence report and the statement obtained from the child. After those exhibits were handed in, the prosecutor wanted to withdraw conviction. But because the court was functus officio, and there's no provision in the Criminal Procedure Act which provides for the withdrawal of the conviction, the magistrate refused that application, but he proceeded and sentenced the accused to life imprisonment. And as a result, it is not because of the developments that happened after the conviction. It is because of the evidence itself that we decided that the magistrate was wrong, and we need to set aside that conviction.
Could you also inform the Commission whether the complainant had given evidence in the lower court and described the method by which, or the manner in which she was raped, and identified that it was the complainant that had raped her during her evidence? And how did you deal with that issue?
Can you please repeat? I'm sorry, I didn't
Yes.
follow quite, Karen.
Sorry, entirely my fault for being unclear.
Yes.
I would like you to explain to the Commission how you dealt with the fact that the complainant testified during the magistrate's court trial
Yes.
of the manner in which she had been raped, that it had been the complainant that had raped her, and that he'd given her 50 rand at the end of the ordeal.
Yes.
How did you deal with that evidence?
Yes. You must remember that evidence didn't come out of examination in chief. It was only when the child was cross-examined that it was put to her that she informed the forensic nurse that the accused raped her, and after that gave her 50 rand. And she confirmed. She never mentioned about the issue of the 50 rand in her examination in chief. And the further aspect is that she said she informed her cousin about this rape ordeal. The cousin was called by the court as a witness, not the state, but by the court as a witness. She came and explained and said, no, this child never informed her about this rape incident.
Are you satisfied that the fact that an 11-year-old doesn't inform close relatives, and here I'm speaking more generally, just to understand the method of analysis, if an 11-year-old child doesn't inform family members at the time of the rape, that necessarily indicates that the rape did not occur?
No. And even in my judgment, I didn't say that.
No, I'm just asking for your comment on that
Yes.
view. How would you approach that issue of a young girl not disclosing a rape at the time it occurred, and perhaps only doing so many years later? Would that affect her credibility,
Not at all.
in your view?
Not at all. If you look at Section 59 of the Sexual Offences and Related Matters Act, it says that the delay in reporting the matter, the court cannot draw any inference with regard to the delay in reporting the matter of young children in sexual offences cases.
Thank you, Chief Justice.
Thank you, Commissioner Kane. Commissioner, MEC, are you now ready, or should I proceed with others in the meantime?
No, that's the same matter that I wanted to raise, CJ. I just want to raise this question, maybe if you are comfortable, Advocate Mosopa.
Yes.
Do you think your conscience is clear on this matter of an 11-year-old?
My conscience is clear, MEC.
Clear.
It's clear.
You really believe there was no miscarriage of justice on when you take into consideration the kind of cases that are now happening in the country concerning children and sexual assault, and the emphasis and the line that you took on the questioning more of this 11-year-old than the perpetrator? You really feel your conscience is clear on this matter?
Yeah, my conscience is clear, MEC, and I'll tell you why I'm saying this. The social worker who was assigned to compile a pre-sentence report is an independent person who was not involved in this matter at all. She went there to interview the child. She didn't have an interest in this matter. The child was clear. She volunteered this information to him. But what I'm saying is that despite the developments, the evidence itself, I had the benefit of reading the record. And I've read the record once, twice. And I'm satisfied that, and my conscience is clear on that aspect, that the conviction was wrong.
Compare this case with the speed and the manner that you handled that case of the people that were thrown in the lake, and all the evidence that was presented before you. If you compare the work that you have done with that particular case that many felt that you have done extremely well, take into consideration the time, the evidence, and the difficulty of that particular matter, and this 11-year-old, what would you want to share with us concerning those two cases?
Yes. My starting point, MEC, will be this. Cases and circumstances differ. With the Rose Park matter that we are referring to, there was an overwhelming evidence against the accused. There was also DNA evidence which linked one of the accused to the commission of the offense. And with regard to this case of the child, I'm not saying I'm insensitive to the rights of the young children in sexual offenses matter. But AMC, one thing, I've taken an oath of office that I'm going to administrate justice without fear, favor, and prejudice. That's actually what I've done in that. And then I think I've done it with upholding my mandate, that is the constitutional mandate, and my accountability to the Constitution and the law.
Thanks, Chair. Thank you, sir.
Thank you, MEC. 3 follow-ups. One, the first by Commissioner Didiza.
Thank you, CJ, and good morning, Advocate.
Good morning, Commissioner.
Having listened to you and your perspectives on how you believe you dealt with that matter, if I may ask, have you had any reflections on how such matters in the future, particularly when it involves children, could be dealt better by our judiciary?
Thank you, Commissioner. I think the problem starts with the National Prosecuting Authority, because the onus rests with them. If they can be afforded a proper and adequate training, especially in relation to these sexual offenses cases, I think that will better the position. And the problem with the judiciary deals with evidence. It deals with evidence, and if it's in the mind of the judge who's deciding over that matter is that the evidence is not adequate enough to secure a conviction, then the person has to be acquitted irrespective of the fact that an 11-year or a 5-year-old child has been raped.
Through you, CJ, do you think our court system as it stands today does facilitate for minors, particularly children, to be able to express themselves in an environment that they can be able to give, their evidence on what might have happened in such circumstances? Or maybe something else might have to be done to create that enabling environment where minors are concerned?
Thank you, Commissioner. I think our court caters for that. We've got a situation where minor children below the age of 16 years testify through intermediaries. Those are trained social workers. And then we've got a situation again where these young children testified in offices separate from where the accused is sitting from. So where the child is testifying from, she doesn't see the accused, and she can freely express whatever happened to her.
Isn't what you need the following, though? The revival of the Tutusela centers, and maybe doing what the French do, combining the police with the judiciary having an investigating magistrate, so that some of these sensitive matters, you have the benefit of a presiding officer who will not sit, involved to guide the sensitive investigation such as this at a very early stage?
No, I believe that will be the correct approach, as Chief Justice.
Minister?
Well, just on the Tutuzela centers, I can confirm that we at least have 55 nationally running, but obviously it's a far cry compared to the need out there. But of course, constraints is another factor. But just in terms of the intervention of the court itself, you are saying that the cousin was called in by the court, I don't know whether to say Merumotu or something. I do not hear you say the aunt who is alleged to have briefed the child, if you like, to make this, in quotes, false accusation against the accused, was equally called in to testify. I didn't hear you say that. Did that actually happen? And if it didn't, why wouldn't the aunt's testimony? I mean, this is a serious, indictment on the part of the aunt, which should itself attract some kind of criminal action against the aunt.
Yes, thank you, Minister. The aunt was called as a state witness. She was not called as a court witness. She did testify in the matter.
And how did you assess that? You mean in the court of court or in the appeal court?
No, in a court of court.
Now I'm talking about the appeal court. You, as the appeal court, if I understand correctly, took it upon yourself to call in the cousin to testify. Is that a correct understanding?
No,
so this was all happening in the court of court?
Yes. What I'm stating is what is based in the record of the lower court.
I see. I suppose no evidence is led on appeal.
No.
Yes.
There was no request from both the...
Yes, no, I just wanted to clarify that. Now, what was your assessment of the testimony of the aunt against the backdrop of the testimony of the child, that in fact the child was prompted by the aunt to say this? Did the child simply say that the aunt told her to say so? Or did the child go further than that and say, yes, the aunt told me to testify in this manner, but that is not the true version of what happened, according to your reading of the evidence? What really happened there?
Yes.
It's not entirely clear to me.
Yeah, let me try to explain it better for you, Minister. What happened, the child testified and said the accused raped her, and she was cross-examined. The aunt was called as a witness, and she testified and said the child told her that the accused raped her. Then the state closed its case. The accused testified. After the accused's testimony, he requested a pre-sentence report. The social worker was assigned. That is when the child told the social worker.
Okay, let's just leave the pre-sentence report aside for now.
Yes.
Let's just focus on the record of the proceedings leading up to the conviction.
Yes.
And not what transpires thereafter.
Yes.
And just contain ourselves there.
Yes.
Now, the child, according to your reading of the record, testified even under cross-examination. The child testified, wasn't, I thought the child was cross-examined, wasn't the child cross-examined?
She was cross-examined.
Yeah, I thought somebody was saying no. Maybe I had it in my other.
Yes.
Yeah. Now, during cross-examination, according to your evaluation of the evidence on the record,
Yes.
Was there any discrepancy at that stage that was apparent that would have escaped the presiding officer to the extent that it could only be picked up during the pre-sentence examination?
I'm now getting confused, Minister. You say I must leave the pre-sentence aside, but you are now bringing it in.
No, I'm just saying, if we focus exclusively on the testimony of the child, both at the stage of evidence in chief and cross-examination, just there,
Yes.
all right, was there anything that was apparently contradictory in the testimony of the child at the time, according to your own assessment
Yes,
of the testimony of the child, which the presiding officer might have missed, in your opinion, at that stage, before
Yes.
we get to the
Yes,
second
there were lots of contradictions. And the magistrate in his judgment acknowledged the fact that there were contradictions, but he said due to the age of the child and the time last after the incident and the time when the child raped, that it should have maybe caused such kind of contradictions.
What kind of contradictions were of such a nature you considered fatal enough, and yet the magistrate did not consider fatal enough to the case of the prosecution, for example? I just want to understand how you did your own evaluation.
Yes. The major contradiction relates to what she told the forensic nurse about this rape incident and her testimony. They completely differ.
Wait, I thought the forensic nurse comes after, or at the time of the testimony.
Yes, but under cross-examination, what she told the forensic nurse was put forward to her.
I see.
Yes.
Okay. Thank you, Chief Justice.
Thank you, Minister. Commissioner Malema.
Thank you very much, CJ. Now, were you the only person who had this matter on appeal?
No. Thanks, Commissioner Malema. I was with the most senior and experienced judge. We were two on that matter.
Do you mind mentioning the judge?
I don't mind. It was Judge Ravi.
Judge?
Ravi.
Yeah. And then the two of you have agreed on the judgment?
We agreed.
Now,
and maybe to add, Commissioner Malema, if the senior judge in his capacity, if I was wrong on my judgment, he should have corrected me and said to me that, no, I don't agree with you, and that the JP should have constituted a full bench to deal with that matter.
yeah. Now, given the sensitivity of the matter, should judges be considerate of emotions, or should judges just consider the facts when dealing with matters?
I think we should consider both, Commissioner Malema, but what counts most is facts.
So, okay, let's leave the facts. Are you saying the judges should consider emotions when dealing with matters?
No. We must concentrate on facts.
And in this case, all what mattered was the facts before the judges.
That's correct, Commissioner.
Thank you.
Commissioner Nyambe.
Thank you, CJ. Morning, Advocate.
Morning, Commissioner.
Do you believe in judicial activism?
Yes, I do believe.
Can you share with us your understanding of judicial accountability?
Judicial accountability means that I must be accountable to the Constitution and the rule of law. I must be open-minded in dealing with the matters that comes before me, as opposed to judicial restraint. And I think when executing my duties, I uphold the Constitution, the mandate given by me by the Constitution, and that I regard as judicial accountability.
What might you regard as your weakness?
Commissioner Nyambe, I'm easily disturbed by minor things. That is my weakness.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Singh?
Nothing from my side, Chief Justice.
Are you covered?
Yes, thank you.
Thank you so much. Commissioner Nokesi?
Thank you, Chief Justice. Commissioner Malema covered my question.
Thank you so much, Commissioner Fori. Tell me that you are also covered.
Thank you, Chief Justice. Good morning, Advocate.
Morning, Commissioner Fori.
I just want to deal with a couple of issues raised by the General Counsel of the Bar in their comments.
Yes.
And I think it's only fair that you get the opportunity to react to that. And then secondly, I would like to deal with reserve judgments and the time periods for delivering judgments.
Yes.
Firstly, the GCB, if I may refer you to paragraph 7.3 and 8.1 of the comments. In 7.3 they say, although the candidate appears to be an experienced advocate in the areas of criminal and labor law in particular, there appears to be somewhat of a lack of exposure and experience in the broader field of law required for the appointment of a judge. The JSC may deem it necessary for the candidate to obtain further exposure and experience through further acting appointments in the High Court. And then 8.1, I'm going to read and then allow you to comment on that as well. The candidate's judgments reveal that he has good linguistic skills in English, although he could benefit from proofreading his judgments beforehand. Would you like to comment on those two, let's say, perhaps criticisms against you?
Yes. Thank you, Commissioner Fori. Let me start with what is stated in 7.3, lack of exposure. It's a fair comment. It's a fair comment based on what I've submitted in my application and based on what they have reviewed. But I can add that since that time, when I submitted this application, I was invited by the Judge President for a term as an acting judge, which I accepted, and I was doing civil work. I did 2 weeks of annual post-motion. I did 2 weeks of post-motion. I did 2 weeks civil trials, and I had a week in civil and criminal appeals. And further that, I've been given an invitation to act again, which I've accepted for the whole term next term. And then I think that their concern will be addressed, or they've already been addressed in the meantime. And
So
with regard to the second...
Sorry, if I might just summarize, you say you think it's fair comment, but since you've acted continuously and you think it's been addressed, is that how I understand your answer?
Yes, I'm saying it's a fair comment, but since I submitted this application, I was given an opportunity to act for the whole term, where I did civil work.
Okay.
I've also been invited again next term to do civil work. That is for the whole term again.
Okay. 8.1?
8.1, it's also a fair comment. I accept the criticism, and then I think that will help me in future with the judgment writings.
Thanks. And then the second question, if I may then just turn to the time that you take to deliver judgments, and I look at the document distributed by the Judge President. I'm sure you're in possession of that as well.
Yes.
And I'm going to just refer you to some of the matters mentioned there. On the first page thereof, the date of hearing of the matter was in October 2016 and judgment was delivered in April of 2017. on that same page, which is seriously concerning to me, the date of hearing is given as March 2016, judgment only delivered in November 2017.
Yes. Thank you, Commissioner Corey. These are criminal trials. These are criminal trials which involve a lot of accused. The date of hearing maybe might be misleading because this matter, we had it for a very long time. I didn't write down all the dates when which this matter appeared. But it's a criminal matter which took a very long time to finalize. And then on that date where given the date of judgment, that is when I delivered my judgment.
So can I just understand, you say the date of hearing is not necessarily the date on which the trial was concluded?
No. It's basically the date when this trial started, when the trial started.
And then, if I may just quickly go through the rest, there's a matter of Manzini on page 2, date of hearing April 2017, date of judgment October 2017. Page 3, June 2017, the matter of Sandani, December 2017, the judgment.
Where are you, Commissioner?
I'm on page 3.
Yes. Yes, Commissioner.
And then page 4, the matter of Mafie, October 2017, and that must be a mistake, date of judgment April 2017, I assume that's April 2018.
Yes.
Then the matter of Maluleke, October 2016, date of judgment December 2017.
Yes.
And then as you go along, it appears as if the situation does improve, and I must say that to your credit, but there are a lot of matters that appear to me to be bordering on the 3 months, let's say, a danger zone that you enter. For example, on page 8, the matter of Royal Haskon something, May 2018, judgment August 2018, the same with Pretorius and RAF, and then there are further matters listed there which I'm not going to specifically refer to. Do you have a difficulty with the preparing and delivering of judgments and sticking to the time periods that are set as acceptable time periods for that?
No, I don't have a difficulty, Commissioner Ford. If I have to explain with the criminal matters, we have situation where a matter is scheduled for maybe 2 weeks. In that 2 weeks, we don't finalize evidence. We then have to postpone the matter to another date. Normally, we'll do these matters during recess because we cannot do it during the term as per the directive of the Judge President. So it will take time. For example, this current recess is only 2 weeks. And we've got a matter where it is involving a lot of evidence to deal with. We cannot even finalize that in 2 weeks. We have to postpone it to another recess. So it will take time, and it will appear as if I've taken time to deliver judgment. It's not like that. It's that to finalize the matter, it took time. And with regard to the other matters, I don't think I've reserved judgment for a longer period of time.
Perhaps in future, in conclusion, when you prepare such a list, you should rather put the date of the finalization of the matter and then the date of judgment.
Thanks for the advice.
Thank you, Chief Justice.
Thank you, Commissioner Fourie. Commissioner Norman.
Thank you, Chief Justice. Good morning, Advocate.
Morning, Commissioner.
You've been asked about this criminal case of the 11-year-old and I thought in answering some of the questions, at least you would make reference to a similar case of a 11-year-old, a rape case, where you actually confirmed the conviction on appeal.
Yes.
And you've attached that, and it appears at pages 118 and 119.
Yes.
And paragraph 51 at 130, you state that the appellant raped a child who was 11 years old at the time of commission of the offense in 2006 until such time that the complainant was 15 years old in 2009. Is it correct that this child, according to the judgment, reported this matter a year later?
That's correct.
In 2010?
That's correct, Commissioner.
But you still found that there was enough evidence and you confirmed the conviction and sentence on appeal?
Yes.
Yes, thank you. Thank you, Chief Justice.
Thank you, Commissioner Norman. Commissioner Msomi.
Thanks, Chief Justice. Good morning, Advocate Mosopa.
Morning, Commissioner.
Advocate Mosopa, I mean, I've got just one question, and it's really an opportunity now for you to sell yourself, given what the GSP says about the fact that, sorry, the GSP says you are the potential, you are the future. Perhaps you are not ready now. What do you say to that? Why should, that is the counsel that the GSP is giving to this commission. And why should we appoint you, given the comments that they have made, etc.? Thank you.
Yes. Like I've said to Commissioner Fori, it's a fair comment based on what they've reviewed, but I've since that time did a lot in regard to civil work. And I can say that I'm ready for the judicial appointment. And I can bring energy to this profession.
Thank you so much, Mr. Mosopa. Your excuse.
Thank you, CJ. Thank you, commissioners.